Welcome back to House Education on February 17th. Continuing our discussion on the chronic absenteeism bill. We have folks here today from the Department of Children and Families to sort of give us their take and any suggestions they might have. Anyway, we look forward to your testimony and thanks for joining. And if you'd introduce yourselves, the floor is yours.
Hey, good morning, or I should say good afternoon. For the record, my name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. And I'm joined here today by Lindy Boudreau, who is the Director of the Family Services Division Adolescent Services Unit. And thank you for the opportunity to speak to you all about the pending legislation. And our plan is really I'll start off by discussing educational neglect and the responsibilities of DCF. And then I'll turn it over to Lindy, who will do the same regarding truancy. And then at the end, I'd like to talk a little bit about the division's perspective on the bill and in answering questions that you may have. Lindy, did you want to go ahead? I know I introduced you somewhat, but if you want to.
For the record, I'm Lindy Boudreau, the Adolescent Services Director for Family Services Division.
Might actually just speak up a little bit because we have a fan back here that's always running.
So there's the statutory basis for educational neglect is really Chapter 49 that focuses on child abuse and neglect, and Chapter 51, which authorizes the department to conduct assessments to determine whether a child may be in need of care or supervision, which is commonly known as CHINS. And the statute includes assessments for educational neglect. And together, these statutes both define when DCF may become involved and what the limits are of our role. So a report of educational neglect may be considered for acceptance when it is alleged that a parent or a person responsible for a child's care knowingly fails to enroll a child in school or provide education in accordance with Vermont law. And through the caregiver's inaction or actions, if a child then regularly fails to attend school. So educational neglect applies to children beginning at age 6 through the completion of 6th grade, as defined in statute. The statute does not provide authority to monitor or support educational or home plans.
Just on the first bullet, sort of written in the passive voice, when it is alleged that a parent or person responsible for a child's care knowingly fails to enroll. Who's making that report?
That could be various people. It could be people in the neighborhood. It could be relatives, anyone that's noticed that there's some absence on the parent's activities. And Lindy, do you know typically who will make educational neglect reports?
Yeah, it could be the same folks that Erica just mentioned. Also, school can also be making those reports. If the student was enrolled before and you know that they're not coming now, they could also make those reports.
So when a report of educational neglect is accepted by the Family Services Division, a family services worker conducts what is known as a CHINS-B assessment.
I can ask another question. When a report of educational neglect is accepted, is that the same thing as received?
No, sometimes
You know about the difference then?
Absolutely. Sometimes just in various reports we get to the hotline, they'll come in, but they need to meet our statutory qualifications to be accepted and then assessed and reviewed by our staff. So sometimes we'll get a report that doesn't meet criteria and we'll tell the individual, this isn't a report we're going to take in and pursue, but there may be other things that you can do to help the family. So what I'm talking about are reports that actually meet the statutory qualifications to be accepted and then move through our system for assessment.
So would I be right saying a neighbor calling in might not be something that's accepted?
Depends on what they say. It depends on whether it meets the statutory qualification for ed neglect. So this includes, part of the assessment includes contact with the child, contact with their family, household members, the person that actually made the report, possibly school staff or others involved, as well as service providers. And we do also visit the child's home and do some collateral fact gathering if necessary. Additional steps, depending upon what happens with the assessment, can include a coordinated service plan meeting, additional home visits, referrals to community-based supports such as BARGE or intensive family-based services, the designated agency, others really depending upon what the family needs.
Fine. So as Erica mentioned, we have two different ways the department manages concerns around product absenteeism or truancy. So the educational neglect sits in our front end, and truancy is outlined in our policy. So policy 60 talks about youth who are haven't been in school for 20 days or longer. So that's the definition that we currently use for truancy. And so truancy applies per policy from grade 7 up to the age of 16. If a youth turns 16 in the year that they've already been enrolled, the expectation by statute is that they complete that year. Some folks think that the magical age of 16 releases youth and their families from the obligation to attend school, and that's not accurate.
Is that 20 days, 20 absences? That's not cumulative, that's per year, or how does that work?
Well, so it depends on the school and the truancy policy. So currently it can be throughout an academic year or it can be a calendar year. So we've had folks who may have 19 and then school ends in September. The school might end in the summer and then they pick up in September and they might get 2 more absences. And so the state's attorney will look at that collectively and say, now we hit the threshold. And they might file for a CHINS D, which is the truancy statute. So typically with truancy, what happens is those reports sometimes, again, it depends on the school and it depends on the protocol, may or may not be called into our hotline. Typically, those truancy concerns are not accepted at the front, we call it first read, by our centralized intake unit. Is referred to the local districts, and some districts will accept it based on their truancy policy, and some may not. But oftentimes they may not be accepted at that stage, but it flags that information for the local office to know that there's concerns around this family and this youth, and that at that stage it's being called in. That typically means that the state's attorney is going to be filing a petition for truancy in court. So the statutory response that we have for truancy is what we call a youth assessment. And this is outlined in 33 VSA 5106. And the focus of the youth assessment for the department is working with the youth and the family to understand what's behind the behavior. Why is the youth not going to school, and working with them to identify the risk and needs and development of a school readiness plan with the youth and the family.
First, this question, the second bullet there. Is this supposed to be age 7?
Grade 7.
Grade 7.
Truancy only applies for 3 years.
So we have the educational neglect and then we have the truancy response. So this is around the response of which side of our system is responding. And the reason that it's grade 7 and up is because a truancy petition is based on the youth's behavior versus the behavior of the parent. So who's responsible? At this stage, we're saying it's more the responsibility of the youth. Like the youth has a part in getting themselves to school versus the parent. So a 7-year-old versus somebody who's 12 or 14, there's a difference in how we respond. So,
Thank you.
That's a question. And then it's 20 unexcused absences, not just 20 absences.
well,
Because that we've heard vagueness in policy
Right.
from place to place
Right.
can complicate that.
yeah, exactly. That's
exactly it.
That's the problem. Yeah, that is a complicating factor. And it depends. Some schools say unexcused, some say any absence.
Okay.
So that's part of the problem.
Thank you.
Okay. So as I mentioned, when we conduct a youth assessment, that's typically when the court has accepted the case for CHINS D, which is the statutory definition of filing for truancy. And so again, when we talk about the age range, it's grade 7 through age 16. When we automatically open a youth assessment is when there's been an emergency care order, which means that we have sought, or a party has sought custody, DCF custody of the youth because of concerns of truancy. There's been a conditional custody order that's been issued. Again, concerns of truancy have arisen to the level where we've sought court involvement. There's conditions have been placed on the parent to help support getting the youth to school, and/or there's a post-merits finding of truancy, which means it's made it through the process. The court's made a finding that yes, this has happened, and we then are a party to the case, and we open a youth assessment. And so again, at that stage, in other circumstances, it doesn't rule out that we can't do it we might have like multiple concerns that have been reported, multiple years of the same issues with the same youth and the family. So we have the ability to open youth assessment and do some outreach and some community-based referrals prior to seeking court intervention. As I mentioned, at that stage, we really want to make sure that it's a collaborative process, identifying the symptoms of truancy, because we often know that it's not just absence alone, there's something else driving the behavior. And so we want to work with the youth and the family and any other service providers that they may have worked with prior or currently, or who may not be at the table that should be. And so that the youth assessment helps us identify these things. So, okay. As we just identified, you asked about the the definition of excused versus unexcused. One of the programs, Erica mentioned the BARGE program, the Balanced Restorative Justice Program. That's a contract that we fund that provides truancy supports. Unfortunately, we don't have enough staff to cover truancy in all counties. But the Lamoille program, you probably have heard about that. I know that the work on this bill was focused in part on the work that we have done in Lamoille related to the truancy protocol. And one of the things that is successful in that is that all three supervisory unions have one truancy protocol and have one definition for what it means to be truant or to be chronically absent. And so that was one of the reasons that program has been so successful, is that everybody came on board and had one shared definition. Through the conversations that I've been a part of with the AOE around not only this proposal, but also for many years, we've been trying to figure out ways to work together to not solve the issue, but try to move the dial on these concerns. This has been at the core. And so this continues to be a concern and a challenge around the state, is that there's not one definition. Again, with that same thinking in mind, some folks again talk about excused or unexcused and who provides that, who provides permission for youth to not come. And so we see variation in whether or not a school, a trip with their parents for 5 days because they're going somewhere that they think, oh, this could be educational, that might be excused, whereas somebody else may not have that same, that grace may not be given to that person. So we may have also heard about letters. So there's oftentimes letters that get issued to families. When we wrote the protocol, when I was in Lamoille, we wrote the protocol. It started with 5 days as a way to flag if there's some concerns, what's going on, can we reach out? And oftentimes we at DCF wouldn't become involved because that was successful. It kind of interrupted the cycle. We were able to get in there and talk to the families and see how we could support the continued attendance at school. The outreach around that is not consistent again with the school. So because every school district or school itself have different truancy protocols, processes different. So parents experience something very differently around the state. Some folks don't do a letter, they just simply call. So another concern that has created complications is lack of resources around this. So not all schools have a truancy officer, and I use that language because that's the language in statute, which drives me crazy, truancy officer, but that's the language. So not everybody has somebody who can serve that function or can even pay that close of attention to attendance. The last bullet is a concern. And if students are not showing up for 10 consecutive days, some school districts will disenroll them. And so then no one's watching that youth, or no one knows if they're not coming to school because they're not technically enrolled anywhere.
Wow.
Yeah, I mean, there are big questions around that. That actually happened.
It does happen. It does happen. And it's interesting because I've been with the department almost 33 years, and that was new to me like 2 or 3 years ago. Some of the districts were saying, "Oh, did you hear about this?" And I'm like, "No." So I was working with Ann Bornero and folks, and I was like, "What's this?" And just because I had never heard of it. And she said, they said, yes, some schools do it. I don't have a grasp on who's doing it. I know that there were some counties that were doing it. But it does still happen. The truancy is a conversation that we have at DCF with our staff quite often, and this is still happening.
Is schools unenrolling or districts unenrolling? Schools.
We had a comment from, we have superintendents in talking about, doing away with what they call the letter of shame. But right now we don't even have a chronic absenteeism law, which is all about truancy. It doesn't call for a letter or a phone call or anything, but are you suggesting that we need consistency around the response, and that a posted letter probably isn't the best approach?
That's exactly it. I agree 100% with the consistency, so that we can get a real good sense on, the balance of the problem. If everybody's doing something different, you don't really know who has issues and which issues can be best addressed. And in terms of the letter, I mean, sometimes, particularly if the letter is drafted in a way that sort of makes it seem like DCF involvement could be coming and sort of making our department the agency that's really the heavy involved, I don't think that gets a good response from families. And what we're looking to do, as Lindy described, is to be really collaborative with families and get to the root cause of what's going on.
And the letter was created again out of the Memorial Protocol that's been around for a long, long time, but it really wasn't rooted in this heavy threat. It was an invitation to join them and see what was going on. Over the years, we have several variations of this letter, and there's some are very threatening. They threaten court because at that stage, the next step is petition to court, and then behind that is DCF custody. And that happens. Kids come into custody because of concerns of truancy, and that shouldn't happen.
Not when there are just so many other ways and other agencies that can, come in and assist to help the family get the child back into school. So I do want to turn to the bill itself. We really do like the overall direction of the bill and its focus on chronic absenteeism as a systems issue, as opposed to something that's simply a child welfare issue. Because as we talked about, there can be all kinds of reasons that a child can be not coming to school, where if there's more systems involvement, the issue can be solved. We talked about the shared definitions. We absolutely support that. Clear protocols and greater consistency across the districts. Because just really identifying those elements and concerns and addressing them early on is really the more uniform and productive way we believe to address the problem. As Lindy noted too, we have been working closely with the Agency of Education for more than a year. We've been collaborating with them, including discussions with their consultants, really just to better align education and child welfare responses to attendance concerns. Looking ahead, DCF anticipates that our role will be really more active in terms of collaborating with AOE as partners and as part of the stakeholders group, really supporting the development of a model policy that they're thinking of in the bill. And what we want to do is really provide some clarity around expectations as far as DCF's role in that process, which will really be important in terms of where we are in terms of what our work is and how that's really bounded by our statutory authority. And it's important to us not to exceed that authority, because we do know that that's when families feel stepped on. And that's not what our role is. That's not our intent. We want to be a support to families.
I think that's a valid point. I think often the DCF is used as the threat, and bringing them in. I had a very specific question for you that has since gone out of my head, but overall supportive of where this is going. Again, we find ourselves with a list in front of us of trying to sort of categorize excused and unexcused absences. You didn't come in with any specific changes to that, which I would assume means you don't necessarily have any suggestions to that.
No, just a strong desire for some consistency
Yeah.
across the board.
Yeah, and as Erica mentioned, over the past year, we have been working, I've been working with them on the development of those statutory changes and the model policy. So I was aware before it was submitted to committee, what those changes were. So we kind of had those discussions with the AOE and support where they've kind of landed as a presentation.
What is the status, I mean, of a model policy? Is there a draft out there? We've only sort of have our bill in front of us, which does not have a model policy.
The last time, so there was, I'm not sure the exact status of it right now because the AOE realized, oh my gosh, this is a big lift. And so then they were able to find and work with like 2 consultants that they've hired. So the policy work, I think, has shifted a little bit to supporting the work of the consultants. But I have seen it and it does look reflective of the truancy protocol that we developed in the Memorial. So it's similar to that. But what I understand to be next steps around that are related to what the consultants are finding in all of their conversations with stakeholders. And that's going to come back and inform the model.
Excuse me.
But I feel like the bulk of the changes are going to sit in the policy versus the statute.
And related to that, because this is the second time someone's brought up the model policy today. And I was reading it, I mean, this is way out of my field, but I really would love to know whether the description of what the model policy should be, the boundaries around it. I mean, have you reviewed that? And in the legislation, I'm saying, and does that cover everything?
Are you talking about the parameters that they?
I'm looking at it here, and it feels, I just don't know. It feels, it should be vague, I think, to some degree, but I want to make sure it's capturing, because so much is related to this model policy.
Yeah, when I read that, it feels to me, and not having been the person who drafted, I'm not sure what their intent was. It feels like that is still allowing for room for local control around the development of a policy that meets the individual supervisory needs or school needs versus just having one model policy. Which my preference, recognizing that may not be possible.
Your preference is one policy.
I think what we've learned from the conversations with Lemoyle is that yes, having one is the strongest, but I've recognized that comes with a lot of work behind it. And I don't know that that's possible.
Yeah, I agree with you. It's sort of like we need to be able to balance each individual district's character, but at the same time, we need the ease of having one policy so that we can have that standardization across the board. So
Yeah. And I feel like the standardization is coming in with the same folks making the decision around whether or not it's excused or unexcused. I did notice that there's still variation in that. And also the parameters in the bill. I can't remember all of the list of things that you mentioned, but it did say that they will have, that will be at least the standard of the model policy, not beneath that. So for me, it felt like if the model policy is coming in really strong, then hopefully the rest of the policy will follow suit.
Yeah, it says meet or exceed.
Yeah, so I felt like, for me, I felt like that was probably a safe way to, at least as a start, try to provide that consistency around the state.
So I'm if I just have one more thing on this. Again, from my perspective and everything we've been hearing, it really is about the prevention. And I just want to make sure that the framework around this model policy is focused on that. So if there's anything that needs to be changed in the legislation, that's really important. So I hope you'll take a note, just make sure.
We can definitely do that.
How many educational neglect cases do you folks deal with each year that have to do with absences from a school, I'm sure that they exist within the sort of the homeschool structure that we sort of don't have anymore. But just,
It's
I
funny.
just don't know if it's 2 or 200.
It's so funny you asked that because we pulled that slide out because we knew we had.
We all have time,
But
I brought it just in case. We can send you these
Yeah.
charts, yeah, so you can talk about that, actually.
oh,
Shows them.
Because we did get a request saying, we have an issue with having sort of really relaxed the accountability with homeschooling, and that we've provided sort of an out that allows people to say, oh, well, my child's no longer enrolled, we're doing a homeschool program now. And then sort of that shuts down the ability for you folks or others to be involved.
And that was the legislative change that was certainly, I wasn't aware of that happening when it happened. And it does leave a bit of a gap, so there were some concerns around that. But from my understanding of that bill was that they couldn't unenroll their child and then seek a homeschooling plan. They couldn't, the plan had to be approved before they could disenroll their child. So I think that was the intent of that to be the safety net. But yeah, once that happens, we have no statutory authority to monitor that plan or to monitor, they're no longer truant, and there's no concerns about neglect because they're not.
That backs up what we heard previously. Yeah.
so this was the slide we removed this morning, and it's the number of accepted intakes for ed neglect statewide between 2018 and 2025. And you can see it's roughly, there's some dips, but there are no huge areas where I'd say we should be surprised. The numbers are relatively stable, but for 2019, which we attribute to the pandemic. So, and when I look at really 2021 through 2025, you're ranging between 167 cases. There's a low of 126. So around, that's sort of the span.
And when we switch over and talk about neglect, now we're only talking about sixth grade and younger.
We have truancy, a lot of data, we have separate data on truancy.
I was just making sure I had the words right.
Yeah,
You're totally right.
It was pretty similar.
We're talking truancy.
sure. So with the truancy data, this information is not, these aren't reports, these are cases that have actually been opened by the court for Chins D. So these are actually court cases. And so you can see prior to the pandemic, there was significant drop that happened around the time of the pandemic, and then it started to rise back up. And during that time, there was some the protocols related to truancy at the local level were shifted. So some folks, it was very few schools that actually continued to call in concerns of truancy during the pandemic. And as we got a year or two out, and that started to change. So schools started to employ their truancy protocols again. And so that's when you see the numbers starting to kind of climb back up. This also is a reflection of lack of court activity during that period of time. So court cases were not happening. They were, but we had a tiered response in the family division around, like certain Chins cases. But so truancy in those cases were not prioritized in that first initial year. So that's reflective of a couple of things. And so these cases will have spot in our caseloads, if you will. So we will be working in cases where there is an active truancy petition.
Yeah, thanks very much for sharing the information with us, and your perspective is quite helpful. Oh, yeah, I'm sorry.
Could we just get a follow-up in writing is fine of schools that are unenrolling students and where that's happening?
So I would have to get that from POE. We don't have that, but I can follow up.
Thanks.
Great. Thank you.
Thank you.
All right, let's take a very quick 5 minutes, and then we're coming back to discuss our